H2, Cambric, Deshawn. H2, Cambric.
Yes, sir.
Again? Again?
Again.
There are some people that I see over and over and over and over.
Listen to that cadence. The repetition isn't filler, it's a spotlight. When someone shows up over and over, the courtroom hears a pattern, and the audience smells a narrative. Problem, persistence, escalation. Cue the tension. This isn't just background noise, it's the hook.
Miss Cambric.
That string of charges reads like a timeline of escalation, petty to serious, sporadic to sustained. Legally, prior convictions matter. They shape bail, sentencing ranges, and prosecutorial strategy. Emotionally, they prime the jury. You've got history, you've got a pattern, and the judge just put a big, bright arrow on both.
Since 1999, deadly conduct, 99, failure to stop and render aid, 2002, failure to identify as a fugitive from justice. Now let's get into 2000s. 2004, theft, 2004, theft, 2005, felony theft, 2005, theft, 2005, theft, 2006, theft from a person, felony theft from a person. Possession of a controlled substance, 2007, possession of a controlled substance, 2007, and 2008, theft, 2009, possession of a controlled substance, 2010, possession of a controlled substance, possession of a controlled substance, possession of a controlled substance, 2012, theft, assault, theft.
Quick legal primer. Those are the Miranda rights, spoken to preserve any later statements for court. But notice the difference between custodial interrogation and mere contact. If she wasn't being questioned in custody, statements on scene can still be admissible. Also, surveillance video is the prosecutor's best friend here. Objective, repeatable, and persuasive.
16, 17, 18. Now, 2019, theft, 2020, theft, 2021, theft, 2021, theft, 2021, criminal trespass, 2021, theft, 2022, theft, 2022, criminal trespass, 2022, theft, 22, theft, 22, theft, 24, theft, 23, theft.
Charging Strategy 101. The dollar amount can flip a theft from felony to misdemeanor, but prior felonies can still trigger enhancements. Prosecutors sometimes undercharge, negligence or strategy, but judges notice, and so do defense attorneys. Trivia for the audience. $98 might read like pocket change, but on a record like hers, it's a red flag, not a pardon.
23 theft, and now another theft. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be.
Ooh, GPS and a retail ban. That's heavy pretrial supervision. Judges can and do impose location restrictions and electronic monitoring as conditions of release when they believe there's a risk of reoffending. Practically, a GPS gives prosecutors a paper trail if she steps foot in a forbidden store. For the audience, that's not drama, it's enforceable control.
Yes, Judge. On August 29, 2024, officers responded to a theft of business.
Here the courtroom flips from punishment to intervention. Dual diagnosis means they see both addiction and mental health issues. Judges love options that combine monitoring with treatment. It checks the public safety box and gives the defendant a path to stabilization. Audience prompt: which matters more here, accountability or rehab? Drop your take.
This at a Walmart in Harris County, Texas. Officers made contact with the complainant, the loss prevention associate, who stated on August 28th he contacted officers about a shoplifting, but no officer responded to take the report at that time. The complainant showed the officer the surveillance video, and the officer observed the defendant select a blue tote, walk towards the automotive section, look around to see if anyone was observing her actions, and select multiple Benzoyl motor oil cords off the shelf and conceal them in the tote. The defendant was then observed walking towards the health and beauty section and exiting through an emergency fire door without attempt to pay for the tote or the concealed oil. How much the value? Let me check the OR, Your Honor. It's not in the DIMS. And I'm guessing because they know it's going to be reduced to a misdemeanor, they just now file it as misdemeanors, Michael, instead of a felony?
I'm sorry, what's the question, Judge?
Do they hence assume intake that it's going to be reduced to a misdemeanor as to why they filed it as a misdemeanor?
You know what, Judge? This has been happening a lot, and I'm not sure why. I think, honestly, a lot of it is negligence into not looking at what their criminal history is before they file the charge. Quite honestly, because I see it a lot, and I don't think there's any policy for it.
And Your Honor, total is $98. Amber, I'm going to find that there's probable cause to go forward with the case. I'm now sending you for a drug test. I want to know what, if anything, is in your system, and you're to come right back, and then we will discuss where we go from here. I'm going to put a GPS monitor on you, and I'm forbidding you from going to any store that you have a prior contact with in a theft case. Do you understand? And if I find that you have any contact with any of these stores, I'm going to make your bond so high your teeth are going to fall out. Do you understand?
Sir.
Catch and release days are over. No more catch and release. We are going to get to the bottom of why this continues to happen. And if that means some kind of treatment facility with a dual diagnosis residential program, then hey, but now you're working what? 30 thefts? Stops today. First things first, I'm sending you for a drug test. You must come right back. And if you fail to come back, if you fail to take the drug test, your bond will hit the skyline. You understand? We need to do a deep dive, Alex, into every single store that theft, that all those thefts come from. And just, I mean,
Foster,
I know, if we can just forbid from going to any and all retail stores in Harris County, I mean, just.
Yes, Judge, if you would like, we can create a list.
Yeah, I'd like to do a dive into every single theft she's done and
Yes, Judge.
I was sitting in the dirty box store. Going right that way.